All right, let's bring back in criminal defense attorney, former prosecutor Josh Kolsrud. Josh, I think the defense is doing the exact right thing here. At the end of the day, you know, insinuating this is the mother, the person really with the most concern for this young lady, and she didn't really do anything about it. That's got to tell you something about the tenor of the conversation and what actually happened, and really the credibility of the complaining witness.
Yeah, you know, this witness is a double-edged sword. On the one hand, it helps the prosecution because it explains why the victim didn't come forward to disclose to the police in a timely fashion. But on the other hand, it shows that even her own mother had doubts about the original disclosure and the veracity of what she was saying. And that's coming out here. The defense, although they need to be careful, you know, to stay away from, you know, the emotions that can really lead juries to quick verdicts, because this is an emotional type of case. I would really just stick to the timeline if I was the defense and stay away from how the mother was feeling in those moments.
So, all right, you have this testimony from the victim's mother about what happened, but you also have the defendant's behavior, because in the 2008 case that he faked his own death, that he took off to Europe, that he was there was an international manhunt for him. And so these things to me point to, of course, well, he must have been involved or done it, because he took off and hid, faked his own death, multiple names. What are your thoughts?
Sure. So in order to understand motive, oftentimes you need circumstantial evidence. And flight is always used by prosecutors to show consciousness of guilt. And that's what's happening in this case. So there should be a jury instruction, oftentimes there are, that say if the jury finds that the defendant fled the country, that they may infer his consciousness of guilt. And it's devastating to a defendant because really, it's going to, I think, force him to take the witness stand and explain his actions, because there is that inference there that is the 400-pound gorilla in the room. I mean, anybody who flees the scene isn't acting like an innocent party. They're acting like somebody who has a guilty mind. And that's a very hard burden for a defendant to overcome.
Except in this case, there is something the defense can argue here, Josh, because she didn't report it, so there were no rape charges pending for this case. He had another case in 2008. That person went to police, but the police wouldn't press charges then. They didn't press charges till almost 10 years later when another investigator came in and looked at the case. He was on the run for a fraud case. And that kind of goes to my question. A big part that I think the prosecution's case is showing that he's a bad guy, that he had these fraud charges, that he treated her badly, he made her pay for the rings, he was acting badly, critical of her, et cetera, and then you bring in the other person who claims that he raped her. All those things really lend towards a conviction.
That's a great point. You know, the reason why he left, you know, even according to the newspaper reports, was because of that 2008 charge, right, of another sexual assault case. So you're absolutely right. You know, the defense will be able to bring that in and say that he wasn't fleeing in this case, so there shouldn't be an inference in this case, because at that time there was no allegation. You know, the victim, had not come forward yet and hadn't done so until years later. So great point.
You know, there are no charges, but I'm going to argue that he still, if convicted, knew what he had done, if he's found guilty of this. All right, Joshua Kolsrud, thank you so much for joining us today.